for posterity's sake, and also to go up on the ALA national blog, so that members from all around Australia can appreciate the content as well. It's my pleasure to welcome you all here today and thank K&L Gates, Phil and Lynn for having us and ALA for the sandwiches. We have here Rufina Cheung from CCH, and Rufina is the portfolio lead for commercial law. She writes and edits in the area of competition and consumer law. Previously, she was the writer and editor for Walters Kluwer's contract law and intellectual property reports. She's worked as a lawyer in the New South Wales office of the DPP. She has also worked in the New South Wales Crown Solicitor's Office and New South Wales Attorney General's Department. Rufina is one of our great ongoing presenters. She's spoken to us a number of times and is always brilliant. So if you wouldn't mind just welcoming Rufina with me, we look forward to this session.
Thank you, Albert. Hello, it's good to be back. So the last couple of years, I've been talking to you about copyright. Today it's slightly different. I'm talking to you about unfair contract terms. I'll be talking about what the laws mean for businesses, big and small, and I will be just talking about how the law's changing what it means. Unfair contract term protections were extended to small businesses, and this will take effect on the 12th of November this year. This means for the next 7 months, all businesses should consider reviewing their low-value, standard form B2B contracts, which might be used in transactions involving a business that employs fewer than 20 employees. In the review process, this may involve flagging terms that may be unfair and then considering how to change or remove them to reduce the risk. So, in this talk, I'm planning to give a quick introduction to the law of unfair contract terms. I will explore which terms may be unfair, who will be affected. I'll give some examples, and I will also run through some practical ways in which big businesses and small businesses can deal with unfair contract terms, both in general and also in relation specifically to this new extension in the laws for small businesses. Okay, so what is the law of unfair contract terms? Put very simply, a term of a contract which is unfair will be void. That is, it will be unenforceable and treated as if it didn't exist. And this happens in certain circumstances. I'm going to run you through those circumstances, and I'm also going to take you through some exceptions. A term of a contract will be treated as if it didn't exist if all of these things are true. Firstly, it's unfair. And secondly, it's a standard form contract. This basically means a contract where one party imposes the terms on another party, basically on a take it or leave it, one size fits all basis. And thirdly, it has to be a certain type of contract. Under the current law, that is a consumer contract. When November rolls around, this will be extended to a small business contract. There are also some other criteria, and I'll go through those later. But first, what I want to do is unpack what it means by small business contract. There's basically two limbs that need to be satisfied. One has to do with the number of employees, and the other has to do with price. So the magic number for the number of employees is 20. To be a small business contract, one or more of the parties has to be a business which employs fewer than 20 people. And the magic time is when the contract is made. And when we're doing this, we count up the number of full-time, part-time and casuals if the casuals work on a regular and systematic basis. So we use a headcount approach regardless of the number of hours worked or the workload of the employees. And then moving to the second element, it's price. To be a standard form contract, the upfront price cannot exceed a certain amount, and that amount differs depending on how long the contract lasts. For short contracts, up to 1 year, we're looking at $300,000. For longer contracts, more than 1 year, we're looking at not more than $1 million. These financial thresholds are actually pretty high. So the estimates are that it will catch about 95% of small businesses. So let's move on to those other criteria that I was talking about. For the new laws to apply, we're looking at small business contracts. We're looking at standard form, take it or leave it, one-size-fits-all contracts. And there's a time factor here. So we're looking at contracts that are entered into, renewed or varied after 12th of November 2016. So we're looking at new contracts or contracts that are renewed after November, and variations. So if you vary the contract, then the unfair contract term protections, the new ones, will apply to that term, the one you varied, but not to the other older parts of the contract. And the contract has to be a contract that deals with certain things. So the contract must be for the supply of goods, services, land, or financial products or financial services. And then there are the exceptions. So it can't be an excluded contract or an excluded term. So let's have a look at these excluded contracts. Certain shipping contracts are excluded. Also excluded are the constitution of a company, a managed investment scheme, or some other body. And there's another exception, which is if the small business contract is already covered by a law that is listed in the regulations. This is an exception designed to catch contracts which are covered by an industry-specific law which is enforceable and equivalent to the unfair contract terms. So this is designed to reduce regulatory duplication, and it will be interesting to see what laws are set out in the regs. So we're thinking maybe the Independent Contractors Act, possibly the Motor Dealers and Repairers Act in New South Wales, but there are some differences which may lead to them ultimately deciding it's not equivalent enough. So Treasury has consulted on this. The deadline in order to get it, your suggestions looked at before the November start date has already passed. But if you want a bit more information on this, I've got much more detail in our contract law reporter and our competition and consumer law reporter. But it wasn't just contracts that can be excluded, it's also terms. So these are fairly fundamental terms. If you've got a term that defines the main subject matter of the contract, you can't then turn around and say, oh, it's unfair and it's void. And also the term that sets the upfront price, again, you can't make it void on the grounds of unfairness. And then there are terms which are required by law or expressly permitted by law. And there's quite a bit that sits under that. But I want to focus on small business contracts, so I'm just going to move on here. I want to make 2 points at this point in the talk, and that is that the new laws are mainly designed to protect small businesses in their dealings with big businesses. But they're not actually limited to that. So they do cover contracts between two small businesses. And what this means is that all businesses, big and small, should consider reviewing their low-value standard form B2B contracts. And this even covers not-for-profit businesses. The next point that I want to note is that the new laws cover the situation whether the small business is the supplier of the goods or services or the acquirer of the goods or services. So to give an example, the small business might acquire internet services from an ISP, and the new laws would catch that. Or the small business might sell goods to a big retailer like Woolworths, and the new laws would also catch those kinds of contracts too. So, what is unfair? We've talked about the types of contracts that are caught, but I also want to quickly run through what makes a term unfair. A term will be unfair if all these three things are true. 1, the term would cause a significant imbalance in the parties' rights and obligations under the contract. And 2, the term is not reasonably necessary to protect the legitimate interests of the party that comes out ahead, the party that's advantaged by the term. And 3, the term would cause detriment to a party if it was actually applied or relied on. It doesn't matter whether that detriment is financial or non-financial. And the last point is that when a court is considering whether a term is unfair, it also must look at how transparent the term is and also look at the contract as a whole. Transparency has a number of elements packed into it. So firstly, to be transparent, a term must be presented in reasonably plain language. It has to be legible, it has to be presented clearly, and it has to be readily available to any affected party. Okay, now that we have the theory, I just want to run through a few examples. So let's think about the types of contracts that might be caught by these new laws. There's a lot of them. A few are up there on the screen, and I'll run through a few more. Where there's a very wide range of contracts that will be affected. Just a few would be franchise agreements, contracts to supply internet services, contracts to supply utilities or office supplies, cleaning services, waste management services, advertising services, IT services. You might be looking at loans to small businesses or leases that a small business takes, leasing a shop in a shopping centre. Some insurance, but not all. So private health insurance and CTP would be caught. Or a contract to buy motor vehicles. And as I've already mentioned, a contract between a big retailer like a supermarket and a small supplier. And also contracts for the transport of goods by land or by air. But I've already mentioned that some shipping contracts are excluded. So those are examples of contracts. Let's look at some examples of terms which might be unfair. One of the big ones is automatic rollovers. There's no guarantees at the moment, but there's a feeling that automatic rollovers will be likely to be unfair, especially if you're looking at a rollover clause which automatically renews the contract for a very long time, like 5 years, and the new fee is much higher, and there are fees to terminate the contract early, and those fees are too high, and the rollover happens without notice to the small business, or whether there were some really onerous hoops that the small business had to jump through in order to give notice that they wanted to end the contract. So that's a big one. Another one would be unilateral one-sided price increases. So if the supplier said, or the lender said, I'm going to jack up the price, and the small business can't immediately end the contract without consequences, that could be unfair. Or another one would be to change the deal. So if the telco or an ISP single-handedly changes the amount of available data or calls under your plan, that may be unfair as well. Or another example is compulsory acquisition of franchises at a less than market rate. There are many more examples. I've got a pretty thorough list in our reporters, but those are just a few to give you a taste of what we're talking about. So let's get to the good stuff. What do these changes, the new laws, mean for businesses? Well, we've already said that an unfair term can be treated as if it didn't exist. But the contract will continue to bind the parties if it can operate without that term. It is not a criminal offence to include an unfair term in a contract, which is maybe causes a sigh of relief, and there are no pecuniary penalties for doing so. But there are consequences. There are remedies available. They include things like court-awarded compensation.
So
Say again?
So that includes court compensation as well?
Yeah, court-awarded compensation can be is one of the options. I have a longer list. So injunctions, the court can vary the contract, the court can order a refund of money, and the court can award compensation. Yeah, there's a few different remedies available there. So the court can declare that the term is unfair and therefore void. The court can do this if someone applies to the court, and that somebody can be the small business, or it could be the ACCC, it could be a state or territory regulator, it could be ASIC. the government has set aside $1.4 million to the ACCC to enforce these new laws. So I think it's fair to say that we may see some action in that space. And now we're moving on to the really good stuff, which is the practical steps. What should businesses actually do about these laws? First of all, we'll look at the steps to check whether you should be worried about the new laws at all. And secondly, we'll look at steps to fix it if you think you should be worried. So on the should you be worried at all front, first you check whether the law applies. And I've given you a very quick rundown of when the law will apply. And then secondly, you want to analyse the risks. You want to consider how thorough an approach you want to take to complying with the law. This might depend on how important the contract is to you, how much money it's worth, whether it's a very long-term contract. You might look at, maybe you think, okay, I'm only going to fix the really glaringly unfair terms and the rest I'll just wait and see if anything develops. Or you might want to make your contract extremely friendly to consumers and small businesses, or you might go somewhere in between. And then you'll apply the tests that I talked about to decide if the term is unfair and if it's transparent. Now we move on to fixing the law. So if you've done your review and you've flagged some terms which you think are a bit questionable, maybe unfair, then there are a number of things you can do that may help to make it more fair. So one of them is making it mutual. I've already talked about one-sided terms. That's in a contract where one party can do something and the other can't. You could look at making it so that both parties can do that. Both parties can change the contract, for example.
So the court takes that into consideration?
Yes.
I'm assuming that it
it's
does.
a factor.
You don't have to go to get. You can do this. You can do this just as part of the contract rather than going to court.
Yeah, this is how you draft the contract.
Okay.
This is at the stage where you're looking at all your standard form contracts and fixing them up a bit.
Okay.
Yeah, but making it mutual isn't a get out of jail free card. The court will still look at the practical effect. Maybe you say both parties can end the contract, but in reality it still is better for one party than the other. The court will look at the practical effect. Another one is balancing contracts, balancing terms. So sometimes it's not really feasible to make a term apply to both parties, but you can balance it out a little bit. So, for example, if you had a term that lets one party increase the prices all by themselves, then you can balance this out and soften it a bit by saying you must notify the other side. You have to give them an opportunity to end the contract, or to agree to the price hike, or to negotiate, or maybe pick an alternative. Even if you have a balancing term, it may still be unfair, but it helps. Next is narrowing. So if you have a broad term that covers everything under the sun, that might be more likely to be unfair than a term that targets specific risks. And that moves on to reasonableness. If you make a term more reasonable, it's less likely to be unfair. So if you have a term that goes to the heart of the contract and undermines that, it's more likely to be unreasonable. If you have a term that excludes liability for a complete failure to perform, then that's a bit unreasonable. Like, what was the contract for? And then if you've got a contract that says, oh, the supplier has to perform this, but they can do it anytime they want to, that's also a bit unreasonable. And if you say the supplier excludes liability for things within their own control, their own willful acts or their own negligence, again, that might be a bit unreasonable. So there are ways to make the contract better in those respects. And one more thing is consistency. So if your contract spans a number of different documents, or if it's in different formats, like online and in print, these things should be consistent. That helps make it clearer, and that helps transparency, and it helps with the fairness. So next, one of the things is just draft in plain English. Use good structure. Minimise your use of schedules. This is important because a term may be more likely to be unfair if it is confusing, if it's ambiguous, unclear, if there's a lot of fine print, a lot of jargon. These things are bad. So it should be clear how the term will operate in the different scenarios where it might be used as well. And then another strategy is to go through your contract and make sure that you've clearly disclosed fees, or the amount, the way in which you're going to calculate fees. This helps with transparency. There are a number of cases about this which are also discussed in our contract reporter and our competition and consumer law reporter. I talked about fine print earlier, so if you want to make your term less unfair, then don't put it in tiny, tiny font. That helps with transparency. And again, fine print could be different when you're thinking about an audio recording. If all the terms are just read out to you over the phone. The audio recording, if it is too fast, or if it's too soft, or if it's too monotonous, then that also affects the transparency, and it may make it less transparent and more likely to be unfair. And another thing is, give a copy, a written copy of the whole term to the other party, and a copy that they can keep before they enter the contract, before they pay you. This seems simple, but it helps. There was a case where part of the contract was in an order form, which in that case it was a consumer case. The consumer sent back to the company. And so they sent it back and then they didn't have it anymore. And that affects transparency, it affects the ready availability of the term. So that's something that is good practice. Another thing is the term of the contract. You may want to explain the purpose and the intention behind the term. You can set out the legitimate interests that need to be protected, and that may help. It will help the small business to understand where you're coming from. It will help the court down the track figure out what it was for. And one more thing is severability. So if you've done your review, you've made it what you think is fair enough, but the court disagrees, then what you want is so that if the term or part of the term is void, you want it to be able to be removed to save the rest of the contract or the rest of the term. Under unfair contract term laws, the entire term can be void, even if only part of it is unfair, so severability is important. Another thing is negotiation. This isn't going to be feasible in every case. Standard form contracts are standard form for a reason, but it will really help if you give the other side, so the small business, a real chance to negotiate and an informed negotiation. And if you did this, then the contract is less likely to be standard form, and it's less likely that the laws will apply. So you might want to consider this case by case. You might say, this is a particularly high value contract, I'm going to take this extra step. And if you do that, then you want to document the fact that you've done it, keep the evidence, but at the end of the day, it might not save you. It might still be unfair. It just is one more strategy you can use to help. Another thing is to draw attention to the term, especially if it's a very onerous term. So you can do this by using coloured font, large font, put it in a box, and this will help make it more transparent. You can specifically tell the small business about it, whether orally or in writing. Get them to sign an acknowledgement that you've told them. These things help. Again, it may still be unfair, but they do help. One more thing is to record the reasons why you included the term in the first place. This is similar to the explanation point that I mentioned earlier, but if you decide not to explain it in the contract itself, you might still keep documentation about your reasons for why you put the term in there in the first place. Again, setting out your legitimate interests that need to be protected. One other option you can consider is just deleting the term, because if it's a very unfair term and you think you're rarely going to actually use it in practice, you might decide, I'll just take it out. That's an option. Another one is to allow the small business to opt out of the clause. So, for example, they can tick a box and say, I don't want the contract to automatically renew. This is a relevant factor. The court will definitely consider it. It can still be unfair. And there has been a case about that. Another thing is to make the contract be all tied together. So if your term is very relevant to another term, for example, if you've got an opt-out term and then you've got the box somewhere down the track where you tick, then link them together. In the box, refer back to the term. In the term, refer to the box. These things help make it more clear, more transparent. And you may also want to set up a dispute resolution process to deal with complaints that the term is unfair. Okay, so these things that I've just run through, these strategies for fixing unfair terms, they apply across the board, consumer contracts, small business contracts. But now I'm going to talk about some practical steps that are specifically looking at the new laws. So one is, I've already talked about, the suggestion is all businesses should review their contracts which might be used in transactions involving businesses with less than 20 employees. So that means big businesses should review the contracts that they plan to use with small businesses. For a small business, they need to review all of their low-value standard form B2B contracts because they themselves employ fewer than 20 people, so that's already satisfied. Okay. I'm going to note at this point that the law does not actually require that small businesses to tell the other party that they employ fewer than 20 people. So it's worthwhile for you to think when you're starting a contract to ask the other side, how many people do you employ? It may or may not be practical to do that every time, but it's a question that you should think about. And a small business can vary in status over time. It could be a small business one day and not be the next day, depending on when employees join or leave. The critical time is the time that the contract is entered into. But when you've got a series of contracts, then it could be a series of times. So you have to think about that. So when you're doing this review of contracts, what you are doing is checking whether there are any terms that might be unfair and looking at the strategies I talked about earlier, making the terms mutual, balancing, opportunity to negotiate, and all of those things that I just went through. Now, when I say review contracts, I'm talking about new contracts, and I'm also talking about existing contracts which you plan to renew or to vary after 12th of November this year. So that just helps you decide which ones to review. Another strategy that big businesses can use in response to this new law is to create a separate set of contracts which they plan to use with other big businesses and just separate that out. So you can be as tough as you like. And then, well, within the limits of all the other laws. But then another possibility is that you can structure the price so that it exceeds the threshold. We were talking about 300,000 and 1 million. So if you make the price more than that, then the new laws won't apply. You could do this by bundling costs. You could do this by options to renew, price change notification clauses. There's a few options there. One other thing that you can do in response to the new law is have a process where you ask the other side the number of employees and that you re-ask the question when you're renewing the contract or varying the contract. Again, as I said before, it might not be worthwhile to do it every time, but if you have that as a flag and you think about it each time, that could be a worthwhile step. Another thing is calculating the upfront price. So we're talking about thresholds in the 300,000 for short contracts and $1 million for longer contracts. Check. If you're around that ballpark, then check whether the upfront price is going to be above or below the threshold. So I'm just going to explain what the upfront price is now. It is the price which is disclosed when the contract is made. So it doesn't include fees, which depend on something happening or not happening. So, for example, loan default fees, they depend on a default in the loan. They're not covered. But what things are covered... before I go into that, if it's a contract for the provision of credit, then interest is disregarded. It just makes it easier. So what things are covered? So upfront price could include initial fees. It could include annual fees if these are pre-disclosed and fixed in the future. It could include fit-out costs, fees for stock. It could also include things like fees payable to a third party. So, for example, software license fees under a franchise agreement. All right, moving on is another strategy is checking whether your business employs fewer than 20 people. So, as I said, you'll add up the number of full-time, part-time and regular systematic casuals. And if that number is less than 20, when you enter a contract, it could be a small business contract and the new laws could apply. So if you're in that ballpark, then just be aware as your employees leave and as you hire new ones, just be aware constantly whether your headcount is rising above 20. So now we're looking at things that small businesses can do. If your business has less than 20 employees, you can use the new regime as a bargaining tool. So if that is you, then familiarise yourself with the protections. Familiarise yourself with all the examples. If you're in negotiations with contracts and you think a particular term, like you really object to it and you think it may be unfair, then refer to the new laws. Ask the other party, did you think about this? Would you consider removing or changing it? Maybe doing some of those things that we talked about before to make it less likely to be unfair. Balance it, for example. And then after the commencement in November, if you're in a dispute, what you can do is check if the legislation applies. Refer to it. Ask the other side, look, you're trying to rely on this, but I think it could be unfair. It might be unenforceable. Maybe you want to reconsider pushing the issue. So another possibility, if you are a small business, is to complain. If your business has less than 20 employees and is in a dispute, you can consider complaining to the ACCC. I've already said they've got $1.4 million and they're focusing on these laws. So what you do in this case is you check if is the other party relying on the term. Do you think it's unfair? Are we past November? Do the laws apply? And then if the other party won't remove or change the laws, the terms, and you don't have any resources to sue, and it's a contract that doesn't deal with financial products or services, then you can complain to the ACCC. Alternatively, if it is a contract that deals with financial products or services, then there are other places you can go to. Depending on whether your financial services provider is a member of these dispute resolution schemes, you could complain to the Financial Ombudsman Service or the Credit and Investments Ombudsman, or you could complain to ASIC. And then I have one more suggestion for you, and that is if you are in the transport industry, you could consider creating a separate set of contracts for shipping contracts. I've already said that the unfair contract terms do not apply to contracts for the carriage of goods by ship. This is as opposed to contracts for transporting goods by land or air or other related services. So that's just one very specific last suggestion, and that's the end from me. Do you have any questions? Yep.
I've got a few.
Yeah.
And I should have checked this. we're talking about it's the ACCC, it's the Competition and Consumer Act that's changed, is it?
Oh, there's two acts that have changed.
Are they? Okay.
One is the Australian Consumer Law, which is in the Competition and Consumer Act, and the other one is the ASIC Act.
Okay, I second that. Okay.
They're parallel.
What's a business? Is a business a partnership?
Is a business a partnership? Let me go back and think about that. So you're talking about small businesses?
Yeah, like a partnership usually.
Yeah.
Like a contract between CCH and a partnership.
Yeah.
A law firm.
Yeah.
Will they be cut?
Well, neither of us would be a small business.
Well, they might be.
The law firm could be.
Yeah.
The law firm could be. Let me go back to the definitions. So,
I think it just depends on what it means by business.
I can go back to the exact wording of the legislation to check. Off the top of my head,
I can check
I'm not
that.
sure.
Yeah,
could be. But
I'd look.
yeah.
I'm also wondering if it
Yeah.
would affect small stratas.
Strata.
They're not a business, but
the-
they enter into contracts.
They're an entity, aren't they?
Yeah, they're an entity because they're
The
an own
owner's call.
corporation.
So,
And there's quite a number that would be under 20.
employing fewer than 20, yeah.
No, they don't employ them.
They
but
don't
they're-
employ.
They may and might
They
not.
may have like one,
Yes, they could have
yeah,
one or two part-time employees, but
possibly.
they're operating in the broadest sense of the word business, in the sense of that they're entering into contracts for services.
The legislation doesn't actually define small business. It only defines small business contract. So I can bring up the wording of the
I
legislation.
don't need to know today, but I'd
Yeah.
love to know
All right.
next week.
Send us an email.
Partnership and strata. I can write
Yeah.
that down and consider that.
So one more question.
Yeah.
I've got another question. It's business to business, is it?
Yeah.
So not business to people?
Businesses to people is already
That's
covered.
already done.
Yeah. Business to consumer is done.
Well, I wasn't thinking consumer. I was thinking it's like
The business to people one is limited to consumers.
it sounds. I don't know. I'm pretty old, so
Yeah.
it sounds to me like this. I don't know if the people remember this, but Section 88F of the Industrial Arbitration Act dealt with unfair contracts. It sounds very similar to that, you know, doesn't it?
Definitely not.
I think there are other laws that deal with unfair contracts.
Yeah.
And unjust contracts and
Well, I think more
unconscionable
unjust, yeah.
conduct and so forth. But the unfair contract terms, like this particular law, is up to now has just been dealing with consumers, although there's that very similar but not quite one with the motor vehicle dealers.
So if I was a hotshot
Yeah.
employee banking official
Mm-hmm.
and I got sacked by my bank,
Mm-hmm.
could I use this act to?
Okay, if your employment is regulated by a whole other set of legislation.
Well, it wouldn't be because I'm I earn $300,000.
But you're
Like,
not
are you
a small
talking about unfair
business.
dismissal or?
You're talking about unfair dismissal, not.
No. Well,
unfair
sometimes the company employee, sometimes the company's employed. I'm just.
No, it would be another set of
You think so?
Yeah,
legislation.
that sounds like
But it would
unfair
only
dismissal.
be, Phil, if it was a contract for services. So
Yeah,
you're
well,
not you don't
employment
have the
services.
status of an employee,
So-
but you behave as if you're an employee. Slightly different.
So-
But individual contracts might be.
Yeah.
No, the business to person type of contracts, at least in the form that they are in this legislation, is
Envisaged.
just for consumers. Yeah.
But what if the person was, their business entity was
Yeah, a contract for the supply of
It wasn't
services.
on an employee basis, it was on a
Yeah.
business-to-business basis.
Like, so if
Business
the
to
person was
business
a
would be under the
contractor, for
current
instance,
ones, the small
Well,
business.
Right.
effectively, yeah.
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 Or a consultant.
Well, the consultancies are situations more likely to have some sort of provision in it that may be unfair. Yeah.
Okay.
I can think of an example with my strata.
Okay. All right. It says a contract is a small business contract if, at the time the contract is entered into, at least one party to the contract is a business.
It's only one person, so a person
employs
could.
fewer than 20 persons.
It's only one person. So if someone was, well, a bank's supposed not. No, not
Sorry, I'm not talking about the employment one now. This was
No, I know,
I was
but
looking
this-
this up
yeah.
for an earlier question about partnerships and strata. I think a partnership, giving the caveat, I'm not allowed to give legal advice. A partnership would probably be a business. Like if you're talking about a law firm, they definitely do a lot of business. Strata, I would query whether that was a business, like an owner's corporation. They're not in it to transact business, really. They're there to manage the strata. So it says...
So it's the primary
business.
purpose.
Yeah, exactly. Like they have to
No, it's the
engage
primary
tradies and
purpose
so forth.
issue.
Yeah.
So it could be a partnership, but it
Yeah.
may not be to
I'm
transact business.
Considering...
Could be just to own something.
Off the top of my head, like I know, for example, trade or commerce has a definition in the Act, but business I'm considering. I might have to look that up as well, whether business is defined in the Competition and Consumer Act. It
What
is an
about
interesting
case
question.
law? Is there some...
Over what is a business?
Millions.
No, what defines business?
Well, this term, a small business isn't defined in the contract, I know that, but business, let's have a look. I may need the Wi-Fi though. Okay, let us have a look. Is it KL Best?
I think it's a State Bank Act, isn't it, or something about?
KLG at T35.
Are there unlimited damages?
Let's have a look. I do not remember any limits.
That's
it
right.
just
No,
says
it's-
it just says compensation. Yeah. I can read you out that.
No, it's fine. I can look that up.
Yeah.
It's never ending, isn't it?
What is never ending?
The implications of this act.
It is quite significant, yeah. And as I said, it catches a lot. Originally, the financial thresholds were lower. It was, I think, 100,000 for the up to 1 year, and it was much less than $1 million. So originally, it was going to catch about 80% of small businesses, and now it's catching about 95%. And if you think about it, there are a lot of businesses that employ fewer than 20 people. So it's very far-reaching. Yeah, many different types of contracts.
So
Yeah.
is this the kind of legislation that, farmers who run a business would be able to take Woolies and
Yeah.
Coles to court over
Yeah.
when they say, well, if you're going to continue supplying us, we're only going to pay you this, although the year before it may have been a much higher amount?
Remember that, for example, terms that set the upfront price are excluded.
Right.
But if you have, for example, we have an agreement and it's going to automatically roll over and the price is going to go up, and then that could be something that's caught. It depends. Like you have to look at the exact thing. Some things are excluded. But yes, this kind of contract would cover small farms supplying to Woolworths, yes. there are actually quite a few laws at the moment that have been using that kind of scenario, like for example the effects test. They're also talking about those things, and there's some disagreement over the effect. But yeah, it's very, very far-reaching legislation. And what I like about my talk to you guys today is it's about law that's actually, it's been passed, it's been assented, it's going to commence in November. Like the last two talks I gave to you guys were about law reform, and law reform can always fall over and not go anywhere. This stuff is really happening. Yeah. I will.
Sorry.
Yes.
Are there any clauses further down about a time frame for those dollar values to be reviewed?
Review. Not off the top of my head, no. Because a lot of these new laws, they do say we'll review in 3 years' time. No, off the top of my head, I don't know any of them. Any scheme to do that. Yeah. But yes, you would imagine that with time and with inflation that they would need to be re-looked at. Sometimes that's built in, but not at this stage. Like some things are indexed, like for example, penalty units. A lot of legislation relies on penalty units. That's now actually going up every 3 years. But this, no.
So it depends on going back to Parliament.
Yeah, they can do that at any time.
I mean, there's no provision to say that it will go back in 3 years.
Parliament can change their laws at any time. Like for example, even with the penalty units one, that one they did it about three times. I think from memory it was 110, and then it went up to 170, and then 180. And I think they probably, the last time it happened, they decided, oh, we don't want to keep doing this, and they put in the 3-year indexing rule. But at the moment, it just says those numbers.
Right. I'm sorry. I'm very ignorant about all this.
Yeah.
When the press release came out about it,
Mm-hmm.
or some explanation, or possibly even in the second reading speech,
Mm-hmm.
was there any indication that there'd be a review of the Act as a whole?
The
after a
Australian
certain
consumer
time?
law as a whole is being reviewed now, this year.
No, but it's not in force yet, so...
No, it's not in
so,
force.
as it is so far-reaching, they would need some sort of review in 3 or 4 years' time for the whole Act, not just parts of it, wouldn't they?
They may decide on another review of the whole Australian consumer law after this one, but I am not aware of anything that's been set in stone yet. I think they'll just get through this one first. Yeah.
One more question.
Sure.
Commentary and stuff, is the CCH or Walters Kluwer loose leaf updated? And what do you?
Yes.
Which one you updating, the contracts one, or are you updating the competition and consumer one?
Both.
So
So I don't know if you all got a handout. At the back, there's the snapshot guide to unfair contract terms. Basically, I've reviewed the unfair contract terms chapter in both the Contract Law Reporter and the Competition and Consumer Law Reporter. And at the end of it, at the beginning, there's a checklist of does the unfair contract terms regime apply to my contract or terms? And at the end of it, there are 2 practical guides. I've gone through both of them with you today quickly. One of them's the main practical guide, and the other one is specifically for the small business contracts. The 2 chapters are up to date. Yeah. So. At the moment, they say will, so come November I have to go through and change the tense, but they're up to date. Yeah.
Is it worth asking, just sort of being a devil's advocate here for a moment, is it worth asking the direct responsibility on the sort of people who belong to this association, so library information services, in particular law librarians?
Yeah.
Because managers in those firms do enter into contracts with both big and small businesses. Some are essentially contractors, but they're a business entity.
Yeah.
They may or may not have a couple of employees, because you said they can be any kind of employee, like just as long as it's regular.
Yeah, it could be part-time.
Very
Yeah,
part-time.
it could be casual. But the casuals have to be regular and systematic.
Yes,
Yeah.
that's
Yeah.
all right.
Yeah.
So that hypothetically,
Yeah.
a library and information manager may be entering into a contract with such a person or such a business. But you said at the beginning it's a standard form.
Standard form, take it or leave it.
So
one
the
size
contractor
fits all.
may have a standard form. I doubt that the library manager would have one for a particular service. But the contractor may.
Are you talking about a contract between a contractor and the Law Librarians Association? Or
No.
No?
Oh, that's an interesting one as well.
So, who's the contractor?
I'm just wondering how it might affect people in this room directly.
Yeah.
So between a law library and a small
CCH.
business? Not CCH.
No, a
but
small
small
business.
But if you're a small firm, then you've got 20 partners. They're all employed. They're not even employees.
How many? There are some firms.
Some firms have less than 20
Point to me
employees.
a firm
I
with
don't know.
less than 20 employees that have a library.
You know.
No. It's about a library manager of a
They
sizable
don't have any
a sizable
libraries.
organisation that is entering into a contract with some form of a contractor
Yeah.
who has come up with a standard contract themselves. So they're trying to sell their business to a library information manager
Yeah.
for something probably very specialised sort of service.
Okay. All right. So, and it would fall under the price threshold.
So in other words, I'm trying to make
Yeah.
it personal to us here
Yeah.
what sort of things that we may need to think about.
All the things I've just mentioned.
Yes, I know.
Yeah.
Yeah.
But so you're looking at the price threshold. It probably will be less than the 300K or the 1 million.
Yeah.
It would be a small business contract if one of the parties employs fewer than 20 people, and in this scenario it is. So you're looking at, is it standard form? You have to consider, is it unfair? You also have to look at the timing, whether it was entered into after November or renewed or varied after November. So that needs to be considered. But then, it might, if all of those boxes are ticked, then it could be called.
Yeah. So the association actually is more likely to be the group of people affected. So, for instance, running an annual conference or a biannual conference would have a contract.
Yeah. With ALA, is ALA a legal entity?
Yes.
Yes.
Yeah.
It's a registered charity.
Okay. So.
It's not a business then, is it?
Sorry.
Is it a business?
No, but the contractor might be a business.
Oh, it's only one-sided. Yeah,
So
okay.
we're
Yeah.
looking
Good
at
point.
our events
Yeah.
called CPO, what do you call PCO, professional.
CPD?
No, PCO.
No, it's PCO, and I can't remember what it stands for.
Okay. Yeah.
Conference organiser.
Yeah.
So ALA Limited has signed a contract.
Yeah. And the other side is a small business. Yeah.
So that would be
Could be
fall
called
under
Yeah.
that.
All that is required is at least one party is a business that employs fewer than 20 people. So it doesn't matter what the other side is.
Yeah.
The other side could be a small business, could be a charity, could be a big business.
Retail leases? Would it affect?
Yes, leases for shops in shopping
Yes.
centres,
That'd be
because
one of
it
the
covers contracts for supply of sale or grant of an interest in land. Yeah, it's covered. That would be under the Australian Consumer Law. Yeah. So,
But the Retail Leases Act would apply because there was a point in there about if no other law applies.
no, if it is expressly permitted or required by another law,
Okay, it's permitted. Okay.
that then it's an excluded. If that term is, then it's excluded.
Because of the Retail Leases Act, clearly.
But then for the other bit that I was talking about, if no other act applies, that was if it's listed in the regulations, and only if those laws actually already have unfair contract term protections
they
in
do,
there,
don't
if they're enforceable and equivalent.
Jeez.
So at the moment they're going through that process.
Right.
Off the top of my head, I think the cut-off was February. I can check that. So let's have a look. February. Yeah, so Treasury invited stakeholders to nominate equivalent laws that should attract that exemption, and nominations had to have been provided by 29th of February in order to be considered before the November. Like, presumably you could still suggest a law if you get enough, but then it might not kick in right at the beginning of November. So, but the minister has to be satisfied of quite a few things before it can list one of those laws in the regulations.
Lovely. Okay, I think I might call it there. Thank you, Rufina.
Okay.
If you wouldn't mind joining me in thanking Rufina. And get through. Thank you again.
Thank you very much.
Thank you.
Nicely wrapped.
Yeah,
Nice wraps.
I did not do that. Alex.